Welcome to the Colorado Trial Lawyer Connection, where Colorado trial lawyers share insights from their latest cases. The pursuit of justice starts now. Howdy, everyone. Keith Fuicelli here for another episode of the Colorado Trial Lawyer Connection podcast. And this one is a doozy. Super excited to have Vern Ready on to talk about a truly amazing $2.7 million verdict against Target on a slip and fall case. And if that doesn't sort of pique your interest and want to know how on earth did you do that, let me give you a little more. This is in federal court. This is a very interesting liability and damages side case, and just an expertly tried case by Vern. And with that, welcome to the show, Vern.
Oh, thanks so much. And thanks for having me on. I really appreciate it. You know, the list of people you've had on is pretty amazing. Just glad to be among them now.
I love that. Thank you for sort of saying that, because I hope that when young lawyers listen to this, they think, I can't wait to get that verdict to come on. And then I hope when they get that verdict, they reach out and everybody comes on and talks about what worked, what didn't work. And really what I'm hoping, and I know that you and I spoke about this a little bit before we went on, that when people listen to these episodes, it empowers them. And they think, you know what? I could do that. I got my case. Let's roll. Was that sort of, I know you had mentioned that you went back and sort of listened to some of the episodes before today. Is that true to you?
Well, it is absolutely true. Like I was, I will blame you for figuring out my voice memo app, because, as I'm listening and doing other things, I'm just like, I've got to get a note on that before I forget it. And there's just so much value that has come from listening to other people and talk about, what went well and of course what didn't. And so that's great.
It does feel like I've heard this on other podcasts. I mean, this is a golden age of information. So for young lawyers that are out there that want to be trial lawyers, their world is your oyster as far as learning what to do and how to do it. And I just want to touch on what you said real quick, which is that on a previous episode, I talked about using that Apple voice memo feature because we get these random thoughts in the middle of the night or when we're on a walk or a jog. It's a great way to put pen to paper, but I really like wordsmithing my opening. Not that I memorize it or read it, but wordsmith my opening, record it in voice memos, and then force myself to listen to myself. And I hear how annoying I can be at times, little pronunciations, and I tweak them. So
right.
I'm glad it helped.
Right. Do you rehearse a lot? Because you say you don't memorize, but I mean, I rehearse a ton before.
That's a great question. I'm going to share because everybody does it different. And to me, we're talking opening statement. And I definitely believe opening statement is the most important piece of the trial. And it's the part you can prepare the most for. Some people that are amazing, world-renowned trial lawyers would never memorize it. And I don't do that. But this is what I do. I will spend a lot of time actually writing word for word out what in my mind is a perfect opening. And it is like from the beginning to the end, and then I will record it. And inevitably, I will end up going through about 10 different versions of that opening, wordsmithing the crap out of it, right?
Yeah.
And then I sort of have triggers for like the roadmap of where I want to go becomes, enseared in my brain. Then I can get up and I feel like, frankly, the opening part of it is memorized, the catch, what did the defendant do wrong? There are definitely parts of it that are memorized, but at least for me, I have found that I can do the opening that way and be engaging and authentic and have great eye contact. Obviously, I don't have any notes, and I will use a PowerPoint selectively so that you're not using it as a crutch. At least that's how I do it. So tell us what's your procedure? How do you go about your opening? Then we'll talk about what you did in this case.
As far as, getting ready, I would say it's pretty similar to what you described. And then I just go over it like a whole bunch of times, just talking out loud, walking around my house, making a sandwich, doing openings, and doing different parts of the trials. And I'll do that. And I think it just makes me personally feel more comfortable so that when I am in front of the jury, it can be more natural. It's not like, oh, where was I going to go next? And how best to say this? And did I get everything in? It's not I wouldn't call it memorization. It's more like just practice and practice and practice and practice so that you feel super comfy by the time you're up there doing it. And you just feel like you can be more natural, and you
Yeah.
can just stand there and talk to people and make, like you said, good eye contact. You can respond to people because you feel like I've got this piece, that opening that you can prepare so carefully in person or in advance, so that when you're in person, it's a little less like halting, a little less like, oh, where was I going with this? And it's just talking about
Yeah, I couldn't agree with you
that
more. And
message.
I know Sean Claggett. I've heard him sort of talk about it as well. It's like by the time they go to trial, the person who's doing opening has done it 20 times. So it
Hmm.
just is so automatic at that point. Nothing's going to throw you off. And I get it. There are lots of lawyers that would never, they just have an outline. They get up there and they communicate, and they have that sort of authentic connection with jurors, and they're amazing trial lawyers. But I do feel like it's the one part of the trial you can prepare the most for. It's the one piece where you sort of know exactly what you want to do. And I found that I end up spending maybe 70%. I frankly end up spending too much time preparing the opening. And to be brutally honest, in Nick Rowley's words,
Yeah.
I completely dropped the ball on preparing closings and rebuttal closings. So I'll
Okay.
be going into closings and it's like, I haven't even really thought about it. I'm just going to go in. I don't have PowerPoint ready. So that's what I need to work on.
Well, let's talk about closings though and trying to prepare them. Okay.
All
So
right.
this is probably completely out of order for where we're supposed to head.
Whatever.
But
It's fine. It's
let's
fine.
just say we're talking about preparing here and how you can prepare that opening. And for me, it helps. Nobody's going to do it exactly the same way, but for me, it helps. And I feel like I can then have that natural connection. But in closing, in for example, in this trial,
Yep.
I was still taking testimony from like the defense doctor the morning of close.
Wow.
And so, yeah, you've got an idea of where you want to head, but things are still coming out that are new. And then, you're taking testimony, taking testimony, taking testimony. You take a little break. You're doing your close, right? And so you have to be open to different approaches, I guess, and remain flexible because, like in this one, my wife helps me with trials, Jennifer, and she's there throughout the trial from start to finish and writing down nuggets about what people are saying and watching the jury for me and all of this stuff. It's amazing help.
Yeah.
And then, prepping close, we're just pacing in a hallway and we're throwing in bullet lines and we're just like, and this one said this and that one said that, and this is we need to put, oh, and this is golden, we're gonna put this in, right? And it comes together. I don't know how you could prep a close the same way you would prep an opening, just because it's so changeable throughout the trial based on what actually comes in and what people have to say.
Yeah. I guess my thought on that is you typically know which, right? It seems like all closings, part of it is massaging the jury instructions, however you want to call that. You've got the verdict form, there's jury instructions you need to go over. So
Mhm.
you can plan that in advance and you can have a PowerPoint with those instructions ready to go. And that's about as best as I've been able to do. I'm anxious to improve on my closings by utilizing more visual triggers. So when there's a theme or something that's come up, and ideally you could start this in opening if you're able to use visuals in opening that are not admitted into evidence, which I know is such a struggle. It seems like in other parts of the country, people have a lot more leeway. But to the extent you're able to take a concept and define that concept with some kind of symbol, and then use that symbol again in closing to trigger the jurors'
Sure.
memories. I want to try that. That's what I'm going to work on in the future. So, with
That
that being
seems
said,
great.
well, if except I'm telling you, it is frustrating. At least in Colorado, it feels like all of the judges believe if you have not stipulated to an exhibit, you can't use it in opening. So it just seems like you got to get really creative in terms of visuals you want to use to assign to a concept. But I think in some respects, that restriction leads to simplicity, which should work in our favor. So if there's a concept that we're trying to explain, be it, somebody didn't have symptoms before and then they did, if we can come up with some visual that is simple, and then we'll talk in a minute about, and actually, I was just in a meeting with our trial team on another case talking about exchanging PowerPoint visuals before the pretrial conference and getting objections
Mhm.
and things of that nature. Maybe we can cover that later. But when they see a visual that is so simple, I suppose they're going to say, well, that's not evidence. That's going to be argument. And unfortunately, I feel like a lot of judges won't let us do that, but it's still worth a try.
Still
So
worth a
that was
try.
a,
Still
that,
worth a try. Because anytime you can put something in your opening and then come back to it later and say, I told you I was gonna, and I
yeah,
didn't. And here it
yeah,
is.
yeah, for sure. And I think
Yeah.
even if you're left with photographs or other evidence that the defense can't credibly say is not going to be stipulated to or
Mhm.
is not going to be admitted, then it's still show don't tell. So
Yeah.
I definitely strongly believe you want to be using visuals in your opening to tell the story because the defense often gets up with their, legal pad and just rambles.
Sure. Yeah. True.
All right, well, that was a heck of an intro.
Yeah.
And I want
Yeah.
to talk about this case, but before we do, just tell us a
Mhm.
little bit about yourself and how it is. I do like to, get to know people a little bit better in our community of Colorado trial lawyers. How is it that you came to be a Colorado trial lawyer?
Well, I guess it depends on how far back we want to go because I've always liked helping people. I feel like everybody needs a little help sometime, and it
Yeah.
feels good to be able to be that help and do that for them. I um, grew up in a family without any without any money, and my dad was arrested for reconnecting the power when they turn it off multiple times, that kind of thing,
What?
and fingernail polish to change the sticker on the car plates, so like, yeah,
Wow.
yeah,
Okay.
we always needed help, and it's I always knew going into law school and through law school that I was doing this because I wanted to represent people, individuals. And so ended up doing criminal defense for a while, interned at the public defender's office. We were doing trials all
Okay.
the time there.
Yep.
You're a prosecutor, right? So like
I
got
was.
those like core trial skills early, right? And then for me, I moved on and did a bunch of family law for a while and then found that I really love doing personal injury. But it's always been representing people, trying to be there to help people who need help. And that feels good. And that's worth coming to work for.
Yeah, and the one thing I feel like that I was able to get at the prosecutor's office and you probably received when you were interning at the public defender's office is before you I feel like you can be free and express yourself effectively, you got to learn the fundamentals. And there's no better place however you do it to learn those fundamentals. Is that the advice if someone's out there listening and they think I want to be a trial lawyer, would you say go to the PD's office, go to the public defender's office, or do criminal defense, family, whatever it is to get in front of people and judges and get those fundamentals down?
Yeah, I would just say whatever gets you into what you truly want to do more
Hmm.
often. There's, you know, people, I think for some folks it's really good to crawl, walk, run. And for some
Yeah.
people it fits to just run. Right. And so I think
Here you go. Fly, fly.
yeah, yeah, right,
Run.
like figure it out, right, and no, I think there are definitely learning experiences all over, so I guess I would just say probably what everyone should be aiming to do is what they love to do, and what makes you happy and what makes you really motivated to come to work. And for a lot of people who do what we do and are amazing at it, they probably wouldn't feel super amazing doing criminal defense or family law or what have you, right? It's just
Yeah.
isn't going to fit everyone. But I would say people, when you're doing the right thing and it feels right and you are whistling on the way to the office, do that.
Yeah. I love that. And the thing that I just caught myself thinking as we were having this conversation about fundamentals and whatnot is that, juries and even judges are a lot more forgiving than we may think. We come in striving for perfection, thinking if we stumble over our words or stumble over admitting a document or something, the jurors are going to punish us. But the opposite is probably true. They
Yeah.
see us in there fighting, not being perfect, and they resonate with that. So I guess what I'm telling any young listeners out there is just go do it. and you'll learn by
Yes.
doing. And if you fall a couple times, it is fine because you're going to do just fine. If just, if you're pursuing a just cause and you've got a good client, then just go.
Yeah, absolutely. And maybe the more often you're going, which is sometimes still trying to learn myself, the more often you're going, the
Yeah.
less worried you'll be about, you know, how are they perceiving me or judging me or whatever. And I know that there are some trial gurus out there who have transcended that concern about
Yeah.
like it's not about me and it's not about how I'm being judged, but I think we all still struggle.
Oh, for sure. For
You know,
sure.
yeah.
Yeah. So how is it you have your solo practitioner? Is that right?
Yeah, I'm a
And
solo.
how tell us about your journey of how you ended up hanging your shingle. And honestly, what advice would you give for other lawyers that are listening that maybe are thinking about doing that or are about to do it? What advice do you have?
Yeah, I think nobody's a true solo, because there are organizations like CTLA out there, there are people like you out there, and the people you've had on who repeatedly say they're willing to mentor and
Yeah.
don't try to just, make it all up as you go. Talk to people who've done it and been there. Listen to these things. Be a sponge. Is what I'm still trying to be, as a sponge, and just take it all in, take in as much as you can, and don't be afraid to do it differently. Because okay, so you've got like all these different approaches to how
Okay.
you prep for opening, or I prep for close, or what we think about jury selection, and should it be exclusionary or should we start educating immediately, and all of these. You get a million ways to do a trial,
Yep.
and who knows how many of those would come out with great outcomes until you're out there doing it and finding out what works and what feels right for you. And experimentation helps us figure that out, I think. And obviously, just doing it and being there and co-counseling with people is certainly a big deal and can
Oh yeah.
help and
Yeah.
shouldn't be overlooked. Like we can do a whole lot of good with co-counseling and a whole lot of learning through that. So yeah, I just think run toward what you want to do and keep doing it and put yourself in the arena and stay there as much as you can.
Love
And
it.
then you're going to come out an expert, right?
Yeah, I love that. I love that. So, all right, well, let's dig into the facts of this case because it
Yeah.
is fascinating. Tell us a little bit about what happened, and then we can get into the trial strategy piece of it.
So my amazing, super credible, awesome client
And by the
was
way,
at the
I'm just going
time
to
of
pause
this
you
full.
right. I'm going to
Uh
pause you
huh.
right there. It seems like every great result starts with that intro.
Oh,
So
really? Yeah. So
no,
yeah,
it seems like
yeah,
the point is great clients make for great results. So if you've got a
yes.
case you're working through litigation and you're like, man, I love this client, that's something to know. Or if you're like, this client's driving me crazy, then maybe that's something you got to consider too. But I interrupted you. I'm sorry.
No, no, don't be
Continue
sorry
on
at all.
telling us. Tell us what
Don't be
happened.
sorry at all. And I think you're right about that because of course, the jury wants to reward people they like,
Yeah.
and so okay. Anyway, she was a 68-year-old Target customer on the
Okay.
day that she fell, and she was approaching the store with her daughter, and there was a sign that had fallen over in the wind, and they kind of walked by the sign toward the front door, and then she remembered, and this was in 2021, she remembered that she had forgotten her mask, and there's still signage at the store that reminded people on the way in during from COVID times to please wear a mask. She turns around, starts to go back to her car, trips over the fallen sign, and then after she's down for a bit, gets some first aid help from Target employees, she goes in and continues her shopping trip with her daughter. So no big deal, no case, right?
Well, do me a favor and back up and describe this sign because what I
Yeah,
mean,
yeah.
is it a sign that's
So,
like in the cement or tell us about this sign?
and that's important because I think a lot of the signs in the parking lots that we're used to seeing are installed and directly into the asphalt, so you don't really have to worry about pesky things like wind. But Target chose instead to purchase these portable signs that have these plastic fillable bases, and you're meant to fill them with materials that are recommended by the manufacturer so that they can resist wind and stay upright up to a certain extent. And of course, there are limitations on the signs,
Okay.
but they have wheels on the side so they can easily be wheeled off next to the store if it's super windy out, and then brought back out as needed. Or you could just have more of them out or fewer of them out. And these signs were used in that kind of drive up, pickup, curbside pickup area
Okay.
that everybody started using in COVID times. So it was meant for people to come out and fill orders and then go back into the store, and you would park and call and tell them which spot you're in. So this would be the sign that's in between the parking spaces that has a big sign on it that says what parking space you're in and so
Got it.
on. And that's the sign. It's like an 8-foot tall sign. It's a large sign, which was of course part of our trial, right? Because I think in a lot of trip and fall cases, the part of the defense is always, well, why weren't you watching where you're going?
Okay.
And so we had, why weren't you watching where you're going? We had, she was fine because she continued her shopping trip after. Can't have been that bad. We had all of that. But it turns out that when she fell, the way that she felt like right hand out and extended. So the palm of her hand struck the ground and then kind of rolled. And the way it extended and injured her hand, she ended up with ulnar nerve damage from the elbow area. We'll say symptomatic ulnar nerve damage from like the elbow area and in the right hand that affected how she uses her hand and caused pain.
So, quick question on that. Is that similar to carpal tunnel type of injury, or is
Yeah,
this different?
it's different. So we had a fight over whether the defense could call it carpal tunnel during jury selection.
Okay.
We submitted questions to the judge in this case in advance, and then the court pulled from our submitted questions to ask their own questions or his own questions. And one of theirs that they submitted mentioned carpal tunnel, and I was, you know, it was one of those situations where you think, should I just let them ask that, or let someone say that and then show how this is so much different than that? Because when you think of carpal tunnel, I'm sure there are very severe cases, and I'm sure they can be very debilitating. But I think a lot of people think of, well, my wrist is a little bit sore because I've been typing a lot,
Okay. Yeah.
and so we thought they were headed that direction. They ended up kind of like throwing that out, but it was so thoroughly discredited that that was just not the issue. And that was kind of the other side that held me back a little bit on wanting to make a full fight out of that was, we're going to be able to show that this is quite different than your standard, like, oh, my wrist hurts a little bit, and it's a little bit sore.
Was
And
there
so,
any issue about the severity of this injury requiring surgical intervention? I mean, was it like a pretty big deal that was debilitating for the client, so that wasn't really a fight, or were they trying to claim, she didn't really need surgery on this?
no, they actually did not go that direction necessarily, that she didn't need surgery. I was more concerned about a defense argument that maybe the surgery made it worse, because we did have worsening over time, right? And so
Okay.
part of what we were doing in our preparation is just like, of course, like with all of these cases, you have to kind of personally get into the weeds with the medical records and know them. As part of that, we were looking for support for her explanation of how this has been, which has been a worsening over time. And so what we went to trial with was examples in the medical record from where there was worsening before the first surgery.
Okay.
There was worsening after the first surgery. There was worsening before the second surgery. Yes, there were multiples. And then there was worsening after the second surgery. So we had a lot of explaining to do on that,
Okay.
because I think my concern going in, of course, was that jurors would be sitting there thinking the entire time, like, okay, well, why all the surgeries if they didn't resolve it, you know? And so we were on that early and making sure we were telling that story with everybody.
So let me kind of circle this back around to opening, because I'm curious, when you're talking about this ulnar nerve injury that got
Mhm.
worse over time, et cetera. Did you include like a teaching section in your opening to address and start to familiarize the jurors with these medical concepts?
Yeah, yeah, because I felt like it was going to be hard. We didn't want that to just unfold or have the defense have the first crack at that, right? So
Yeah.
yeah, and I think opening is so great for that because you can tell a story that is really educating them about the medicine, but it sure sounds like you're just talking about her life and how it impacted her, right? And what it
Okay.
was
Yeah.
like. So it was told from kind of the perspective of, well, what makes a person agree to have surgery to try to fix something. And what were her thinking? What were her thoughts when she's told, just like we're all told around
Yeah.
surgery time, that this probably is going to help, but it might not? And do you
Yeah.
take that seriously? And what's the difference between surgery 1 and surgery 2 for her? So everything, all the medicine education was kind of like put forward as a patient would think about it,
Ah. So did
not
you
as a
do
doctor would necessarily explain it.
so let me just see if I'm understanding this because I'm very intrigued. Are you saying that in your opening, you sort of told the story of the medicine from the perspective of the patient about what was
Yes.
being, oh, that's brilliant. I love that. Like
And
what's
so
being explained to her.
right. And like, why would she agree to a second surgery after the first one didn't work? Well, because they told her it was going to be different, right? They're doing a different thing this time. And we're really confident this is going to help, you know? And then what's it like for her when the pain comes back after surgery number 2, right? And so, yeah, we're giving them cues along the way that because I'm thinking the defense is going to get up and just say, well, if it didn't work the first time, why'd they do it again? It's the same thing again, but it's definitely not the same thing again. And we wanted them to know that right from the start. But I thought it'd be more compelling of just kind of like allow them to imagine themselves in that situation, where they're just like, you'll do whatever it takes to get better when you're in pain all the time. But, you
Yeah,
know,
I I got to tell you a story that I just heard Jordan Logan explain on another podcast because it reminds me exactly of what you just said, which is, you're worried that the defense is going to get up and say, "Well, why did she get this second surgery if the first one didn't work?" And so
uh,
what Jordan did in a different case is basically get up in opening and say, and the defense is going to come in and say, "Well, why'd she get this surgery a second time if the first one didn't work?" And then the defense lawyer got up and was like, "No, no, no, we're not saying that, and we're going to," and said something else. But then they were able to diffuse that argument altogether because the defense lawyer agreed that they were not going to argue that. So, but I
okay,
love that
okay.
idea of telling it from the perspective of your client. And I also want to give a shout out, Sari De Lamont. I've spent some time with her at her trial lab and have
Mhm.
spent some time dealing with her opening, and she calls it like the teaching section. And so what I'm
Yes.
sort of hearing about in yours is like, jurors, in order to do your job here, you're going to have to learn about this thing called the ulnar nerve and go into all this explanation. How deep did you go in opening, or did you just sort of leave it from the perspective of what your client was being told by the doctors?
The opening was given from mostly the perspective of the client. There was very little technical medical in my opening.
Okay.
It was meant to be a story start to finish about her situation, what happened to her, and what her experience through it all was like.
Wow.
However, I did feel the need to slip some medicine in,
Yeah.
again from her perspective though. So it was like I just framed it as like, why would she agree to do it all again? And
Okay.
you're going to hear. And we did this, of course I did this section about like what had to ask ourselves, and sorry de lamont advocates that too. And there's a section in
Yep.
her opening that
Yep.
is like, okay, we have to deal with the bad stuff, right? And so I, after telling a story, I was like, before we brought you here, we had to ask ourselves a few
Yep.
questions and hit
Yeah.
those, right? And then
Yep.
and you kill them. And there was some medicine in there, like, oh, was it the doctor's fault? Was it made worse? Whose fault would that be in the end? Because of course you can always try to persuade a jury that, if a doctor made a mistake, then it's still the tortfeasor's fault. But I feel like that doesn't always feel good to be up there in that position trying to do
Yeah.
that. And that wasn't the case in our case. So before I go too far down that road, I was worried about it being a defense, but it was not backed up by the evidence, and it simply was not the case.
Now, how much time did you spend in opening percentage wise talking about Target and its conduct versus the perspective of your client? Because as you're hearing that, that sounds awesome. But I'm like, okay, but are you violating the rule of spending too much time in opening
Yeah.
talking about your
Yeah.
clients? Like,
Yeah.
how'd you deal with that?
I started with Target. I
All
just
right.
started with Target. And I'm aware of that suggestion that we not start with our own client. And I agree. And I think most of the time, I guess I
Yeah.
agree. I think David Ball makes a really good point about like not bringing your client's name into it at the beginning. My framing of this case was really like corporation versus customer. The
How'd you
jurors
do
are
that?
all
How did you
customers.
frame it that way?
First off, I never said Target. I said Target Corporation every time throughout the entire trial.
Okay.
And there was a lot of like, we called And I should know 4 or 5, but I think we call 4 target employees as witnesses ourselves.
Okay.
And what we wanted to be clear with them is I was up there kind of like just rapping and joking with them a little bit at times, is this is not your fault. We're not blaming you for this. Target set you up. Right. Like it's like the corporation didn't provide you what you needed. They didn't tell you what the wind resistance of these signs were. You didn't have a part in choosing these signs. You didn't have a part in choosing what colors they used for these signs or what colors they used for the
Wow.
parking space. You didn't have a role. You weren't at the table, right? Nobody told you how often to check these things to make sure that they stayed full. Nobody told you what the procedure was for writing them down, all of this stuff. And so you just separate these poor employees who are out there doing their absolute best and the corporation who kind of hung them out to dry by sending these things out with absolutely no guidance whatsoever about how to use them. Yeah, I should say no guidance whatsoever, because they did actually send like a little like use cat litter, which is not recommended by the manufacturer. And there was this whole moment where the store manager who was called by the defense said, well, we know exactly how much cat litter we put in there because it says 50 pounds right on the bag. And I was like, well, these are the buckets that were used. We got that in on another target employee, and they were
Okay.
30-pound buckets. And she was like, well, we'll use 3, and that filled them. But they were 30 pounds versus 50 pounds. Target stores don't sell a 50-pound bag of cat litter, and we knew that. And so we asked her, and she didn't know. And so it was, there was a weight difference based on, it created a question of
Well,
how
and
these
let
things were
me,
filled and whether they were filled properly.
I want to pause for a second because what you were just talking about is frankly brilliant. And it is brilliant for you to call target employees and blame it on the company set you up to fail.
Mhm.
That is, I
We
don't
even
recall.
successfully got that done on the 30B6 cross.
So
So
tell us about that. Tell us how you worked that in to, because I know from reading I know you got a lot of like I don't knows and other things. Number one was this strategy of we're going to have the target employees be sympathetic and the corporation set them up to fail. Did you have that before the 30B6 depot? And if so, how did you implement it in the depot?
okay, so it was maybe a bit low hanging fruit because it was apparent based on discovery responses
Okay.
that we weren't going to get a lot of information because there wasn't information. Like we weren't going
Well,
to get a lot of documents
tell
because
us
there
more about
weren't.
like the discovery responses that led you to that. We're talking response to documents about policies and procedures and things like that.
Well, no, just like the acquisition of the signs, they couldn't produce any documents in connection with the
Okay.
acquisition of the signs. They couldn't tell us who made the decisions. They couldn't tell us who was present and who was not present. They couldn't tell us who made the decisions about whether to create a policy about when to bring them in. They couldn't tell us if anybody even ever considered the wind resistance of these signs.
Wow.
They
Okay.
couldn't tell us if anybody checked the manufacturer website because the wind resistance was right there, super clear, super easy to find, right? And nobody, as far as we know, based on the testimony that was provided and discovery response and all that, as far as we know, nobody at Target ever actually looked to see what the wind resistance of these signs were. And yet they acknowledged sending these signs out all over Colorado. I believe it was obviously national, but they admitted all over Colorado, windy areas, not windy areas, and so on. And nobody's watching the Weather Channel. Nobody's doing anything to kind of know, like, should these be brought in? There's no policy for doing that. There's no procedure other than somebody thinks, oh, they're a bit wobbly. And it came out during the trial that they knew that the signs were falling because they had fallen and they had hit some cars.
Oh,
And
wow. Okay.
the defense during the trial just made it one sign had fallen, that it happened one time. And I'm not sure exactly what they based that on because we had multiple witnesses throughout the trial say, well, yeah, I'm aware of it happening, and it happens maybe like once a month. Or another one was like, it happens regularly. And, the another one admitted that they had sent reports up and about these signs falling. And we got a regional manager on the stand who agreed that she knew and it had been discussed and that she had sent reports up. And then part of the argument in close, and it kind of became like a miniature theme, was that reports were going up and nothing was coming down.
Yeah. So let me
Again,
stop you. Let me stop
corporation
you.
versus employees, right?
Yeah. It's just so masterful because you have regional managers and potentially the corporate 30B6 getting concessions. And then are you saying that like the store manager was, readily admitted, I've never been given any guidance. Nobody ever told me. So is that the juxtaposition that you set up as sort of like regional and corporate knows this, store manager knows that?
Yeah, and we did point out that corporate didn't send any of the documents down with these signs. They didn't, they just sent their own like instructions in an email that they had made up, and then nobody was ever even able to produce that email. And then they
Wow.
had a procedure for things like this. When they do things like this, they're done this way. Well, that's not doing the thing, right?
Yeah.
And then there was also this corporate versus like kind of like the corporate expectations versus the actual boots on the ground, and what was happening was so different. And we were able to point that out in a bunch of ways. One of them was we found the Target ethics code on their website, and it includes some statements about safety being their top priority. And then every
Yeah.
single Target witness, including the ones they called, embraced that immediately. And we were able to walk them through the ethics code, right? And they
Yeah.
embrace. And then we were able to ask them, what was the valid safety reason for choosing signs that can fall over in the wind instead of signs that go right down into the ground? What was the valid safety reason for choosing colors that match the colors on the ground instead of OSHA yellow, which was a standard option for these sign bases, OSHA yellow? And what was the safety reason for not having a policy about not checking how much wind these things can withstand, and then not having a policy, and all of this, and a lot of the answers to that were not present in our written discovery responses. And
Right.
so
Yep.
so I was not surprised in the 30b6 deposition that the witness admitted to absolutely like no prep, because you follow up, and when they can't answer something, you just point out that, hey, you saw this list, you knew what we were going to ask you. What did Target Corporation do to prepare you to answer this question?
Okay.
And
Yep.
the
Yep.
answer was, eh. The answer was, I don't know. Or I called some guy and he didn't know either, was the answer, right? And so, what kind of surprised me a bit is that so much time passed between the 30b6 depo and the trial, and the same witness was the 30b6 witness at trial. And then in front of the jury, instead of what did Target do to prepare you to answer that question, when I got the I don't know, it was Target Corporation didn't really prepare you to answer that question, did they? They sent you here to answer that question for them. They're not here. They sent you to answer this question, but they didn't prepare you to answer it. And she was like, no, they didn't.
Wow. At trial.
Yeah.
Wow. I love that. So, kind of changing subjects. I'm just
Okay.
curious. In a case like this, did you have any kind of expert on like commercial signage or store safety, or did you need any kind of like industry standard expert in this case?
No,
I
I
love
common
it.
sensed it. I common sensed it.
Yes.
And
Yeah.
and by the way, I was worried about that. I was considering that, and it was one of those things that I was thinking is, should we have a retail safety expert? But I felt like they were so off the chart with their own lack of knowledge, their own ability to articulate a standard of any
Yeah.
sort. I mean, they could not tell us a standard, and it's their sign, right? It's their property, and they admitted landowner status right at the beginning of the case. So we had to fight over that. But they couldn't tell us what the standard is, and so it was a reasonableness standard. And and I think everybody in the room at the end agreed that their lack of information, lack of effort, lack of follow-up and follow through were not reasonable.
Got it. So let's talk a little bit about sort of the defenses in this case. What were you facing with respect to the defense doctor? What was the conclusion of the defense doctor? Like this is just degenerative change. You were going to get this problem anyway, type thing.
What he did is he like focused on the urgent care record. And so she went to the, like I said, she finished her shopping trip, and turned out they're actually really good personal reasons for that. So her daughter has these like needs and expectations, and if things don't go as planned, it doesn't go well, and this
Okay.
was a rare day out for them. And so the explanation of why she stayed and continued to shop is actually pretty compelling, and pretty, I don't know, I thought it really showed off her being a caring mother, but they made a big deal out of the fact that she didn't go straight to the ER. And they made a big deal out of the fact that she continued to shop, and it can't have been that bad. But what the defense doctor really focused on was at urgent care. And as part of breaking these records down and preparing for trial, we really needed to like take every symptom she has and find its origin. And there
Okay.
was progression over time. So we're finding like for paresthesias, we're finding like tingling, early reports of tingling, right?
Yep.
And they had overlooked a record where there was tingling. So they believed that the first mention of paresthesias or numbness was like 3 months after or whatever. They were just wrong about that. The urgent care record was mainly like it said hand and wrist. Okay. So they were like, well, there wasn't an elbow issue, you know, and there wasn't a hand issue because the defense doctor decided to just go full on. It was wrist. And the reason that the defense doctor decided to try to thread that needle is because her wrist wasn't really symptomatic after, I don't know. I mean, her wrist hurt because she fell, but it wasn't part of her ulnar nerve damage and it wasn't persistent. And it wasn't really a huge part of the case. And so
Okay.
his hope was that he was going to stroll in and just say, well, the only thing wrong with her was her right wrist. It says that right here in the urgent care record. It does not. But it's, that was their focus at urgent care. So that's the only thing that was wrong. That got better. Everything else that she's experienced is probably due to like typing too much or something like that.
Yeah.
And so that was the approach. In fact, there was, he said that at urgent care, they didn't even care enough to put her in a splint. And by the way, he was wrong about that. And this is where like just knowing the record pays off, right? Like just knowing. And
So let me jump in and ask you because I'm hearing you say that you knew that this defense doctor had multiple errors in his report.
mhm,
Uh, and so I guess the question is to depose that doctor or not. So
yeah,
knowing that you had these punches that would land, what did you do? Depose or save it for trial?
saved it for trial. Did not
Okay. And
depose him.
how'd that work?
It worked out amazing. And it was a little squirrely, as it is to do that, right? Because the big benefit to deposing is you know what they're going to say. You've
Yep.
got it locked in and so on. But and there was progression over time, but we could see that progression in the reports because there wasn't just one report, and she was continuing to treat while we were litigating this case. So
Okay.
her final surgery was like a month before deposition. So we were still figuring out as we went too, but his initial report, he hadn't even examined her at that point. It was a records review. And then
Okay.
he supplemented and then he amended. I think if you call it something different each time, then it's justified. So he's, but, it was like all these different reports and you could kind of see where he's headed over time because at first he was really like deferential to the surgeon. He's a colleague of the surgeon at the same practice, by the way.
Yeah. And,
And
and I read that. And I mean, that's sort of crazy.
yeah,
So tell the listeners a little bit expand on that a little bit more. And I'm curious about if you elicited concessions from the defense doctor, and we can name them, it doesn't matter. If you elicited concessions from the defense doctor that they respect the treating doctor, and did you differentiate the ethical obligation a treating doctor has versus an IME doc? That's probably a dumb rhetorical question, but tell
no,
the
no, no.
listeners more about that.
But yes, I did do those things, and we had also sent her because I was again a little bit worried that the jury might conclude that the surgeon was at fault for some of this. So we had sent her for another opinion, an additional opinion with another hand surgeon who's unaffiliated with that practice, and we had that record in through our surgeon and through our physical rehab doctor. And so it was pretty well covered. And one of the things that I did before the defense doctor testified is because we could tell from his reports what direction he was headed,
Mhm.
he wanted to blame a condition that was actually diagnosed in her left hand, but some of the medical records had gotten it wrong and said right. So again, we've got our
Ah,
issues just like every other case, right? You
yep, yep,
always
yep.
feel like we do focus on those issues we're worried about a lot as we're prepping trial. And And so this guy was going that direction. And with our own doctors, I'd say, okay, so you concluded it was not Dupuytren's or Dupuytren's. I still don't know how to say it correctly. And here's why. And this other doctor, you were aware what his opinion was. And then the second opinion doctor, you were aware what his opinion was. Which doctor thinks is Dupuytren's? Oh, the defense doctor. And which doctor was paid by Target to testify? Oh, that, okay. And so we, before the jury ever heard him speak, we're setting that up, right? And then when he's there, he's I guess he's we weren't entirely sure. So the answer to the question about like whether we knew there were errors in his report, I would say from his reports, there were maybe some things that were wrong here and there. But what we could see from the reports was that he was becoming more adversarial and more specific, that he was going for it. Whereas at the very beginning, we kind of thought, oh, this guy's not going to be that bad. Like he's actually like very deferential to his colleague, which we really
Yep.
wanted and appreciated.
Yeah.
And maybe he's not going to, come out all knives out at trial. And he sure did. He sure did.
So I was curious because I saw your post about it. Talk to us a
Mhm.
little bit about his demeanor and this
Mm,
issue about having to finish a question, a rhetorical question with the word
yeah.
correct.
Yes. Okay. So, as you know, leading questions, we're allowed to ask leading questions. And, unless you're trying to get points in a mock trial in law school, you're probably not going to say correct after everyone. And I actually coach clients. I'm like, listen, don't be that person who sits on the witness stand and says, was that a question? Like, like, don't be that person. Like, we want people to like you. And so just roll with it. The questions sound different on cross than they sound on direct, and that's part of how I prepare my people. No one told him that, because when I was crossing him, honestly, he just seemed like he wanted to stab me. He was like, really, I thought he was pretty hostile, and so when I would ask a question that didn't end with correct or something, he'd just stare at me. And like that moment of silence we just had, like
Yeah,
longer than that,
I love it.
like he would just stare at me. And so then I would say correct, and then he would answer the question. So it was interesting.
I
I've
gotta
had
tell
someone
you,
be that consistent about that.
I gotta tell you a funny war story because I have
Okay.
this is a great war story. So I'm in Boulder trying a case. I forget who the defense doctor was, and I ask him
Uh-huh.
a question, and I don't say correct, and he said, "Was that a question?" And I said, "Well, I think it was a question, yes." And he's like, "Okay." Then he answered it, and then the next question I asked the question, and I said, "Correct." Like that at the end. Just
Yeah.
it
Yeah.
was
Exactly.
so funny, and the
Exactly.
jurors hated him. The jurors hated him,
Yeah. Yeah.
just like yours.
I mean, obviously it was a question, but I get
Right?
how witnesses sometimes like feel like that's a win for them to try to point that out, but I don't think it goes over the way they think it does. And so there was that. There was also just like anger in him. You could tell because he was being corrected about getting things in the record wrong. Like there was a
Yeah.
splint. I showed him that. I showed him where they issued a splint, and he thanked me for that correction. And then I had him finish a
Wait,
sentence
hang on.
that.
Time out. I want you to set that up a little bit more because I'm just curious. So, in the record, he says it couldn't have been that bad because they didn't issue a splint. So, how did you set that line of questioning up, if you don't mind kind of going into the weeds a little bit on that issue?
Sure. So I just reminded him of what he had said on direct, and that he said that she was not issued a splint at urgent care. And to him, that was an indication that her injuries weren't that serious. And that was one of the bases for his opinions that he shared, and so on and so on. As
Yep.
you do that
Yep.
setup, right? And
Yeah.
then,
Yeah.
and then I just asked him. And by the way, at this point in the trial, we're pretty late in the trial at this point, and I think I mentioned before, but my wife helps me with these trials, and she's
Yes.
sitting there watching the jury, right?
Yep.
And we bring this big king flip chart, and we intend to use it for like opening and closing and so on, because I think I think it was maybe Tim Galusi on one of your episodes mentioned that like when the teacher writes something down, so do you. And I think that works really well with these flip charts and opening and close. And I'm sure people use them when they're, you know, working with witnesses and whatnot. But these jurors in particular, they had this little monitor in front of them in the jury box in federal court. That's one thing that's super cool about federal court is one HDMI plug gets you just screens
Yeah.
everywhere.
Yeah.
And the jurors love that. And you could see, and Jennifer caught this, that sometimes we would be talking about something or referencing something in the record, and they would glance down at their screen to see if it was there, right? So they wanted more. So we started
Yeah.
putting everything on screens. We started putting everything on screens and ended up using the ELMO for things that we were going to use flip charts for. But this was an excellent example because crossing this doctor, before he even answers the question, we've got a call out using TrialPad,
Yep.
and we've got a call out from the record showing that a splint is in the supplies, and then we've got a call out showing that a splint was given to her and used. And then he kind of snarkily thanks me for the correction. But there was another major correction that was made, and that was in his direct examination. He read half of a sentence in a record, and he's actually reading the record as he's answering the question. And what he's reading is something from that second opinion doctor we got, who says,
Okay.
at this time, I don't recommend future surgery, but as time goes on, if her symptoms continue, then it's going to be very likely that she's going to need this and this and this and this, right? And that
Wow.
was written a year before trial. That was a year before trial,
Wow.
and she's still in symptoms. And so what he reads is, I'm not recommending future surgery. And he stops. And I was like, that's not the whole. So, I get up there. I
Wow.
was like, and this was the theatrical moment where I'm like, now, doctor, on direct, when you were testifying, and the target corporation attorneys were asking you about this and this and this, you testified about this second opinion. You respect Dr. Sashar. It was the second opinion. You know him. You're affiliated in the past, no longer, but and so on, and just really talked to this guy up. And then you actually read from the record. So this wasn't from memory. You were reading this in front of the jury on direct. You only read half of a sentence. I'd like you to finish that sentence for us. So I call it out. It's on their screens. They're reading along with him. He finishes the entire sentence. And the whole time he's doing that, I'm kind of like giving a look to the jury. And I felt like that was one of those times in the trial that's maybe a little bit rare, where you feel full license to get a little dramatic, right? And kind of just call out with your eyes that something amazing is happening right now. And then in the close, I was able to circle back to that. And this is one of those hallway close editions, right? Because again, this happens like an hour or two before I'm closing.
Yeah. Yeah. Yeah.
And I'm telling the jury, like, if we had not pointed that out, you would not know, because they didn't want to give you that piece. Why would that be? Right. And
Wow.
it was, I don't know, I felt like a snap moment. But knowing the record, right? You got to know the quote.
To say that that is an epic moment is the understatement of the year. I mean, I've never had that great fortune to have a witness walk into that punch. Holy cow. And
Mm-hmm, mm-hmm.
as you're telling that story, it's almost like I'm in my mind, I'm role playing all the different ways I would mess up landing that punch of that or taking that low hanging fruit by being too aggressive, too in the doctor's face, asking, is there a particular reason you chose to not read the rest? I mean, I don't even
Oh,
know.
yeah. Yeah.
It's
Right.
just such an amazing thing.
Right.
Holy cow, man. But go
Yeah.
back to what you said about knowing the record. So let me ask you, when that doctor stopped, did you instantly know, like, wait a minute, he didn't finish the rest of the sentence?
I knew it in the moment.
Wow.
I was like, no, that's not the whole quote. I mean, it's important, right? And that's not
Yeah.
like some super remote piece of the record that you're just like, oh, this happened 3 years before she fell, and I don't remember exactly what was said. No, this is important stuff. This is stuff that we like sent her out to get. So of course we know what's in it, but I think it's a good lesson for knowing the record in its entirety, because little things like that, right? They can if you don't know, they can definitely get away with that live in trial if you have not deposed them. Which I still feel like, imagine all of that happening in deposition and how much better he would have come off live in front of the jury. I think,
Yeah, he would have issued a supplemental report correcting
well, he
all the,
absolutely would have.
well, actually, it doesn't change my opinion at all. I actually knew all of that and
Right,
blah,
right,
blah,
right.
blah.
Exactly. It would have been like
Yeah.
addendum number 6. But yeah,
Right, right.
I felt like even though there's a lot of comfort to be had in deposing, in this case, it would have helped him more than us.
I mean, I got to be honest. I personally have kind of come to the world where I don't really like deposing defense doctors that often, unless it's just going to be to confirm bias stuff, because it costs money. It's then they kind of know where you're coming from. And I much prefer to just sort of have them not know what to expect out of me because I feel like maybe they're a little bit nervous and I don't know. It's just obviously it's a case by case situation. And in your case, obviously it worked out brilliantly. So, final result in this case $2.7 million for your client. Talk to us a little bit. I know we talked beforehand and we're coming up at the end of our time here. What you took away about the importance of either using flip charts or using, you mentioned that the jurors in federal court have little monitors, and that, if I'm hearing you correctly, they almost expected throughout the trial to see things on that monitor, backing up what's being said. So, how did your experience in this trial impact how you will try cases in the future?
We did pivot, and I was proud of us for that. We pivoted to using those screens for everything,
Mm,
and I felt like it was really effective. Closing argument, instead of flip charts, we used an ELMO when I was just writing, just like overhead projector for your teacher kind of thing,
yeah.
and I felt like that really it landed super well, and it really worked well. So I was glad we made that decision. But we also went over the verdict form, and there was testimony throughout our case to try to kind of set up and distinguish physical impairment from pain and suffering. And obviously that's important in part because caps. And so there was testimony that was very detailed about the impairment maybe even being the worst of it for her, despite
Yeah.
pain all
Yeah.
the time. And how that impairment affected her. And then that was all rehashed during the close. And we went through the verdict form on the ELMO, and I showed them the lines. And it's important that this go here and this go there. And it says it says on the verdict form, don't put physical impairment damages on this line. They go below. And then we got a jury question while they were deliberating. The first jury question we got, you'll love this, was, can we have a calculator? And
Oh my God. Never
you're
happened to
like,
me.
oh
Never
yes,
happened to me.
here's a calculator. And then and then the second jury question was a little more sad. It was what do we do? Like, where do impairment damages go? But it didn't say like impairment of quality of life. It didn't say physical impairment. So we're in federal court, and the judge that we were in front of was kind of like already prepared an answer in advance, and then we're just arguing with him about why he should not use it. And his answer
That
was
always
his
works out
answer.
well in federal court.
I know, right? And his answer was, of course, his answer was just like that physical impairment line is for anything you didn't include on non-economic damages, which
Wow.
absolutely I disagree
Right.
wholeheartedly
Yeah.
with.
Yeah.
That's not the law, and I feel like that really hurt us, because then the entire non-economic damages award, or the entire, it was we got economic damages and we got pain and suffering, and zero for physical impairment, because they believed they had included it in the non-economic. And we know that because they followed basically what we asked for on the per diem arguments. So we're
Yeah.
sure
Yeah.
we're
Yeah.
sure that they agreed that there were physical impairment damages, but they put them all on one line.
Yeah, and I have also been the recipient of zero in impairment and like 1.5 million in non-economics. So I feel your
Yeah,
pain, and it doesn't help. I mean, the non-economics include impairment in the quality of life. So I
they
don't know
do,
what we need to
which
do to
we
get rid
never
of that.
said. And maybe that was a mistake, maybe it wasn't, but we never said impairment of the quality of life because we didn't want to confuse them on that subject. So I never used that phrase. I used pain and suffering for
Yeah,
non-economic, and I used physical impairment, and I tried to distinguish impairment from non-economic at every opportunity. But if I had to do over, right, what I would do, of course, knowing, because you never know exactly what a jury's going to get hung up on,
yeah,
but it does make you wish you had a time machine so you could go back and say, no, it's really important hear me on this.
Yeah.
Physical impairment, because we couldn't get a definition in, right? But
Right.
physical impairment, this is the testimony you heard of physical impairment, but
Yeah.
that goes
Yeah.
on this line. That goes on this line. I think we could get away with that,
Yeah,
like,
I've just come to endorse like the Cheney Galuzzi that impairment is the physiologic change of the human body, because
yeah,
then that's like the cause, and the effect is the impairment of the quality of life. But and it's still so difficult to do, but it seems like at least right now that's where I'm landing. So two more quick things since we're out of time that I wanted to cover.
yeah, sure.
The first is, because I know the answer to this question and it's amazing. Tell us about the pre-suit offer that you turned down to go to trial.
We turned down 500,000.
I mean, listeners, they turned down $500,000 on a slip and fall case and went to trial in federal court. Just absolutely amazing. And the last little point that I wanted our listeners to consider, because you've talked about the importance of using visuals throughout the trial. And I would just encourage people, if they have a CVN subscription or to go on YouTube, Mark Lanier is the freaking master at using ELMO in cross. So he goes through and just like does these little diagrams. And it's just like you said, it's just like a teacher. But I feel like jurors are so used to seeing the teacher do that during cross. It was really effective. And it just makes me think that flip charts are underutilized throughout trial. And that's a big Sari de Lamont thing too. Anybody that's like
Yeah,
done anything under
yeah.
her, she's huge about that. So I'm going to endeavor to use more flip charts throughout trial.
Well, I think the question about whether you're using a big fancy flip chart or an Elmo with screens is just the location of screens.
Yeah, agreed.
It's just like what's more visible. The flip chart's huge, and the flip chart's really nice. And the flip chart, I feel like maybe feels a bit more authentic or something when you're using it as like teachery. It's like
Yeah,
it's like yeah, it maybe reminds people of education in a way, but then also just having screens everywhere. And if you do have screens everywhere, then maybe that's the
the
option to
magic sauce.
take.
Yeah, the
Yeah.
magic sauce. Well, and I like flip charts because it takes a while to write on them. So that gives jurors the time to process what
Mm,
you're doing.
yes.
Yeah.
Yes.
Well, Vern, thank you so much. I mean, this has flown by. We could go for hours. Obviously, we could
Absolutely.
talk. We could.
Absolutely.
It
I know
has
I could.
been.
You don't have any trouble getting people on here talking about their trial wins, I'm sure, right?
well, well, no, this one in particular, it's just I don't. I love talking trial strategy. It's like because it's just so
Yes.
fascinating,
Yes.
especially when it works out. I mean, this was a home run. This was an amazing result, and I'm sure you're just
Yep.
itching to get back.
Yes, absolutely. And thank you so much for having me on here to talk about it. It's awesome to do this, especially given how much I have leaned on others doing work like this to prepare myself. It's been a huge
Yeah.
help.
Well, thank you for coming on. And until next time, when we have another person eager to come on, and I'm just going to throw it out there. If you've been following the listserv, there have been amazing verdicts after amazing verdicts because the tide has changed. We don't really face these I mean, it's still out there, but it's not this pervasive problem before. And it's a lot better to be a plaintiff's lawyer now than to be a defense lawyer 9 times out of 10, 10 times out of 10. But it's a good time to be a
Every
plaintiff's
one
lawyer.
of those and every one of those verdicts well earned and just. And
Yeah,
that's what's great
agreed.
about this work. That's what's great about this work. It's
Agreed.
awesome to see that coming through. You get warm feelings in your heart because you know that there's some justice being done, and that's amazing.
Yeah, it's great. We just take a moment of gratitude for the amazing fortune we have to be able to do this kind of work. I mean, I love my job. I can tell you love yours. I love what we do. And thanks for that. So
We're
thank
lucky
you
people.
listeners for listening. Thanks Vern for coming on. Really appreciate it. And
Absolutely.
until next time, we'll be back with another episode of the Colorado Trial Lawyer Connection podcast. Thank you for joining us. We hope you've gained valuable insights and inspiration from today's courtroom warriors. And thank you for being in the arena. Make sure to subscribe and join us next time as we continue to dissect real cases and learn from Colorado's top trial lawyers. Our mission is to empower our legal community, helping us to become better trial lawyers to effectively represent our clients. Keep your connection to Colorado's best trial lawyers alive at www.thectlc.com.